Hello and welcome to another podcast from EQUES Law Group's Oil and Gas Group. My name is Tom White and I'm joined by my partner,
Kate Kimball.
And we are here to continue our discussion of oil and gas law. By the way, our firm has published an oil and gas manual that if you'd like to either get it online or if you're watching the video version of this is what it looks like. You can pick it up at any of our offices. It covers a lot of the topics that Kate and I are going to be talking about during our series of podcasts here. This episode is going to kind of be an introduction to land ownership in southeastern Ohio. And of course, Kate, we're focusing on southeastern Ohio and our oil and gas practice, especially those counties that are in what are called the Golden Crescent, which has happened to be where you grew up, right?
It is, yep.
And so how would you define the hot areas as far as the practice, the leasing, the things that are going on in oil and gas right now? What counties are we looking at?
Sure. So current production, really, if you go along the river from like Jefferson County down into Washington, there's been current production and for the last, 2024, 14 or 15 years by now. So as you move farther west, there's newer production all the time. So it's kind of like that group of counties from the river over in now we're seeing like new leases and well units in Tuscarawas County, further west in Guernsey County, like even some new leasing west of 77, which has kind of been like this line that everybody talks about. And so really that whole area of 10 counties or so is what we'd be talking about.
Okay. I've often heard that referred to as the Golden Crescent, especially the area where you start up in Columbiana County, then down encompassing Harrison and Jefferson, then Guernsey and Belmont, then Noble and Monroe, and then down just a little bit into Washington County. So that's where the production is. That's where we represent landowners who have the potential of realizing royalties for them and their families, potentially for a generation or two, and so that's why we talk about in this episode land ownership in southeastern Ohio. And I've got to apologize to everybody because I am a history and real estate nerd. I think Kate is maybe a little bit too. I don't know if she'll admit it or not. But I actually, we all took property law, real estate property law in law school. Okay,
right.
And that was just a really bad experience for me. For some reason, we started off with a professor who was about ready to retire. He had some mental issues and wasn't a really good teacher. So about halfway through, the dean of the law school took over, and he was not a property law guy. So I really didn't learn all the things about property law until I was studying it for the bar exam. Do you remember property law in law school?
I do. I didn't think it would have been, but it was probably one of my favorite classes. Okay. Yeah, I really liked it. Well, I don't know how often I got called on, which changes your experience in a law school class, but I did really enjoy it.
Was your law school class alphabetized, or did you get to pick your own seats?
I think we got to pick.
Okay. My first year, it was all alphabetized, which in most classes was good because it's a W with my last name, so I was in the back, and that's good. They had a lot of lawn to mow before the professor got back to, unless they started in the back on that particular day. So what we like to start with discussing how southeastern Ohio was settled and how that affects our land ownership of today. Ohio, immediately after the Revolutionary War, as we know, was really the new frontier. We've grown up, I know I grew up in my generation thinking that the American frontier was the Great West, the Great Plains, the Rocky Mountains, etc. But immediately after the Revolutionary War, of course, Ohio was the new frontier, and there was a tremendous influx from the eastern seaboard across the Alleghenies, across the Appalachians, into western Pennsylvania and southeastern Ohio. Why do you think folks wanted to come to Ohio?
So I went to Marietta College. And so there's all sorts of things in Marietta about Marietta being the first permanent settlement in the Northwest Territory. And it's everywhere. All of the like Revolutionary War veterans who went and lived in Marietta. Sometimes I've thought about that and how amazing it is to me that somebody would see somewhere that steep and full of trees and think we should just clear this and make it. Amazes me, like the ambition. So I mean, it was full of resources and land value. So I think that's probably a lot of the main reason coming from like England, where it was not that way at all if you weren't the right person, I guess.
Right. Very restricted in England, becoming restricted in the eastern seaboard. In addition, a lot of the folks that were moving into western Virginia and western Pennsylvania before and during the Revolution were indentured servants who had been released, so they didn't necessarily want to hang around where their former masters were, and they started coming over. So after the Revolutionary War, southeastern Ohio, what became southeastern Ohio, had the advantage of cheap land. It was relatively rich land. It had a lot of raw materials and wood and pig iron, and then it was also easy to transport things around because of the river system through it, especially of course the Ohio River and then the Muskingum River, et cetera. So after the Revolutionary War and before we had the U.S. Constitution under what is known as Articles of Confederation, Congress, of course, created what they called the Northwest Territory, which was, of course, the frontier. And it includes the current states from Ohio out to the Mississippi River, and then going north to Minnesota and Wisconsin and the upper peninsula of Michigan. Ohio was the first state formed out of the Northwest Territory. But back in 1785, Congress enacted what was called the Land Ordinance for the Northwest Territory of 1785 that identify, and you'll notice this, there's a historical plaque at the rest station as you go on US 250 at Tappan Lake, which is, I know, very near where you grew up. Have you seen that?
I don't think so.
You grew up and you just go past it?
People do that, you know? You never stop at the things that are right by your house?
Well, if you're a history nerd, you read those historical plaques like I do. And it's called the Seven Ranges, okay, which one of the ranges kind of ended there in northern Harrison County. And in 1785, Congress passed this act, which specified that the parcels of land, or the ranges they called it, would be subdivided into 6 mile squares called townships. And of course, if you're from southeastern Ohio, you know about sections of land, you know about then townships that are formed out of a certain number of sections, supposed to be square, but often they aren't due to rivers and other natural obstacles. And then you got the sections together in 6 mile squares, supposedly called townships. Now that's the ranges. Of course, you mentioned going to college in Marietta. Marietta was originally purchased early on, even before the Revolutionary War, by the Ohio Company. And so they owned the land in what we would now call most of Washington County, maybe going over a little bit toward Athens. And of course, George Washington was an investor and a surveyor for that company prior to the Revolutionary War. There's also, and we're broadcasting today from our headquarters up in Bunker Hill, which is in Berlin, Holmes County, Ohio. A lot of folks will be up here and a little bit to the south and east of us are familiar with the U.S. military reservation, because you saw in Marietta a lot of Congress, instead of paying Revolutionary War veterans, would say, "Oh, here you get a certain number of acres in southeastern Ohio." So, as a matter of fact, it depended upon your rank. I was looking this up yesterday. I wondered how much you got for the rank. If you were a major general, you got 1,100 acres.
Wow.
If you were just a enlisted person without much rank, you might only get 20 acres. Okay, so it very much depended upon rank, and Congress wanted to not only pay, because Congress during the Revolutionary War was broke, they also wanted to encourage migration and settlement of the Northwest Territory. But with very few exceptions, Southeast Ohio was divided into sections of land, and you can see this whenever you see we spend a lot of time in it as lawyers, but how the county keeps track in tax parcels, there's always a description of what section we're talking about,
Right.
in what township, and then eventually into the various counties. But what lawyers and title people call the root of title, that is, who had the original ownership of this land, was the United States government by right of conquest in the Revolutionary War. George Rogers Clark and Vincennes and everything. We had the right of conquest to that, at least as far north as the Greenville Treaty Line, which is kind of the northern part of what we would call southeastern Ohio. It's also interesting that the Greenville Treaty Line, as it goes over toward the Ohio River, is also kind of the northern extent of what oil and gas people call the oil and gas play, the area of development. I like to tell people, because the Greenville Treaty Line, we're kind of seated just a couple miles south of it as it goes through Holmes County, was of course negotiated by General Matt Anthony Wayne over at Greenville. And according to the eternal word of the United States government, everything north of that line is forever Indian territory. So that's my sole political comment of the day. Why? Well, let's then talk, Kate, maybe a little bit about what did the original settlers, whether you're a Revolutionary War veteran, whether you're buying from the Ohio Company, whether you're purchasing it from a government agent in the Seven Ranges, what's important to know about what they bought?
Sure. So I think, and let me know if this is what you're thinking. Generally, right? When we do title work, if it's possible, sometimes we search all the way back to the patent if we can, where it shows the transfer from. I've seen one from Thomas Jefferson for someone that we were able to find to whoever owned their property in 1820 or whenever that exactly was. And what that person received then would have been a fee simple, right? All of the interest in that property, whatever the acreage was, wherever it was, every right possible to it, right? So from the surface to the core of the earth, they had all rights.
Right.
Which is the best, there's also a fee simple absolute, right?
Yeah.
Which is literally nobody else has rights to anything on this property, which is not usually what we have. The government can tax it. So there's other things that happen, but that's as good of title as you can have is a fee simple.
Right. And it's the original ownership right that the federal government had after the U.S. Constitution was passed in order to, and this is the same concept that they used from the Ohio River all the way to the Pacific Ocean, is the Old English concept. If we could break some of those down, first, the presidential deeds. You said that you've seen a reference to Thomas Jefferson. Mm-hmm. My wife used to have a framing business, and there were actually people who would bring in these original deeds that have passed down from the family. They're written on what's called vellum, which I understand is lambskin.
Sure.
And she would frame these for folks. I've personally seen a deed signed by Thomas Jefferson and also one by James Monroe. So the president obviously didn't have as much to do as he would have now, because it would now be signed by the Secretary of Interior or somebody like that. But a president would actually sign saying your particular family owned this many acres in this section, in this township, in this county. Of course, as Ohio developed, the county boundaries also changed. Washington County was originally probably most of southeastern Ohio, and then as you formed the various counties, it gradually shrunk down to just around Marietta. You mentioned the concept of a fee, and most of us, when we think about a fee, we think of something we're going to be paying.
Right.
And a fee is an old English concept of your interest or right in land. Okay, and so a fee is just an ownership right. Simple, as you indicated, means that you own everything from the surface of the earth to its core, and that is. And fee simple absolute is, I'm not sure if that exempts you from taxes or not.
We'll probably never know, you know.
I think it goes back to the king's ownership of land. If you'll remember, like Sherwood Forest and
That's
the king,
a fee simple absolute.
That's a fee simple absolute. The king owns it, and if Robin Hood and the merry men and and they're hunting deer on, then that is the king's domain. From the surface of the earth until the core, it's the simplest form of land ownership. Within your boundaries, you basically own everything. Now, I would notice, because with the advent of drones becoming very popular among folks, your ownership rights do not include much above the surface. You, of course, have the right to build on your land, and depending upon if your county or your township has zoning or not, that may be regulated, how tall or how big but ownership of the sky remains the domain of the federal government. They didn't give that away. That's how the Federal Aviation Administration can regulate drones and civilian aircraft and et cetera, okay? They have the right to regulate that. But your fee simple interest, your simple ownership, is subject only to the government's right to tax that. Of course, everybody pays property tax if you own that. And the right of eminent domain, which is also referred to as condemnation and appropriation for the, and I'll say, quote, greater good, unquote. Representing landowners, we've run into eminent domain.
Sure. Can
you explain briefly the instances that we run into eminent domain with in our practice?
So sometimes I think people have the impression that things are eminent domain when they may not be. And so it's only in limited circumstances. And when we run into it, it's been like utilities or things like that, right? Where for the greater good of society, this is necessary. And that's where we've mostly run into it.
Right. The areas that we run into is, of course, when the government itself does what's called taking of the private land. And we're familiar with the example that if the Department of Transportation has a state route that goes across your land, and they decide that for safety purposes they want to widen it, they have the right to take another strip of your land. You mentioned utilities. Ohio law permits utilities to take right-of-ways for putting like electrical easements, et cetera. Ohio law is also delegated to private companies the state's right to take your property. And a big issue, it hasn't been so much lately, but we anticipate that as production continues, that is the right of a private company to take your land, to put a very large pipeline sometimes across your land. And you have to go to federal court because that's authorized by federal law. And that I'm not sure, Kate, that you were with us when we were involved in what was called the Rover Pipeline Project.
Right. A little.
Yeah, that was a situation where one night at midnight, the Federal Energy Regulatory Commission, which is called FERC, issued its certificate of need to Rover Pipeline Company, and immediately the next day they filed in federal courts in Columbus, Akron, and Toledo against everybody who had not signed up with them. And that was just about 6 to 8 months of just running hither, thither, to and fro, trying to represent people, trying to get a fair compensation, trying to get protection for their land. But when you have a federal judge who's kind of breathing down your neck in order to get the case over with, and so many people, that's difficult. And I know a lot of landowners have issues with private companies being given the right to take our property so they can make a profit.
Right.
Can't tell you the number of landowners who would say, well, listen, I don't want to be paid one time. I want them to pay me a portion of what they're transporting underneath my land. And that, while that sounds good, we have yet to find a judge or a company who'd be willing to take that. With the settlement of southeastern Ohio, of course, as we get into the 19th century, the 1800s, there's the coming of coal mining and oil and gas production in western Pennsylvania and southeastern Ohio, and that changed things. We talked about owning everything in a fee simple arrangement from the surface to the core. Kate, what did the coming of coal mining, especially production of oil and gas, what did that do to kind of change the way that we think about property ownership?
Sure. So I think that it changed all kinds of things about it, right? Where if you have a fee simple, and it's simple, right? It's one chunk kind of. So when things like coal, which was always there, but it became more valuable or easier to get out or whatever the reason is, it kind of changes how many ways and how often property rights would be splintered in all sorts of ways. Who owns what portions of what? So then we're talking about like layers of earth, right? Like layers of the physical property, and what that looks like and who can own what rights to what portions of it. So that's a really, really general statement, because it can be separated in so many ways. It really can get like a spider web of rights sometimes.
Sure. You're taking a single interest from the surface to the core, and you're kind of like making layers out of it. You and I have both read some old coal leases and coal deeds where they refer to the seam,
Right.
not the formation, but the coal seam. All the coal in vein number 7 underneath my land is what's being conveyed.
Right.
And that's how they describe the coal. In oil and gas, of course, we talk about formations, and generally folks refer to relatively shallow wells, which may be very deep, and then deep wells, which are down into like the Utica formations. We talk about geographic formations. And really, you kind of like a layered parfait or like a 7-layer salad or a cake. You end up with different rights and different ownership of
Right.
these different layers. So, which comes as some surprise to the folks who own necessarily the surface rights, like farmers.
Right. Fairly often.
Fairly often, yeah.
Because nobody knows, not everybody has found their patent from Thomas Jefferson and seen everything that's happened on their property. So it can
Right.
get complicated.
So something we learned in law school, or I learned studying for the bar exam, is this concept of a bundle of sticks. What's that mean?
Right. So the way I think about this is that the parfait itself is the real physical property, and the bundle of sticks is what the owner carries around that includes all of the rights they have to it. And that can be like an infinite number of sticks, right? And I was actually thinking about this morning because we were going to be talking about this, that maybe it should be a bundle of spoons, since we're talking about a parfait instead of a bundle of sticks. You know, like how many spoons can you pass out for your parfait? To what layer? And how would that look? So that's basically the idea of a bundle of sticks is
I like that.
the owner can pass them out, right? Like I can give this person the right to the number 7 seam of coal, or the right to mine it, but not sell it. And I know we'll get into this, I think, in the next episode but
Sure. So the sticks or the spoons are simply the rights that go with the different layers. For instance, the bundle of sticks or spoons that goes with the surface right is the right to build on the land, the right to use surface water, the right to harvest timber, to plant and take crops, et cetera, the things that you kind of think. And really, since that's the way it started, everything was related to the surface of the land. It's the conflict often comes with when the people who have the right to develop the lower levels exercise that right, and that interferes with your surface rights. For instance, I don't know if you know off the top of your head, but I would imagine that there was a lot of strip mining in Harrison County where you're from, right?
There was. My house is kind of an island, actually. It's been stripped all around my house even.
Okay.
So yes, a lot.
And the strip mining did quite a bit to affect, of course, surface rights. It's hard to,
Right.
Strip mining is where they strip away the topsoil and then get down to the coal and start mining that. One thing that I've noticed in southeastern Ohio that I was introduced when I got to know is the concept of county water systems in relatively very hilly areas like southeastern Ohio. And I know there's one in Monroe County, there are several in Belmont County, et cetera. And the reason for that is when you go down to strip out the coal, you're destroying the aquifer. So even after the land is reclaimed, there's no way you can sink a water well in order to get water for your surface rights. So I always found that fascinating that you see that you see that in that particular area, whereas up around here, if you weren't strip mined, you still have a very nice aquifer, especially if you're from Loudonville like I am. We have the large Mohican River aquifer there. Something that started, as you and I know, because we've looked at plenty of deeds, in the 1880s and 1890s, was people selling the land, basically selling only the surface rights.
Right.
But somehow retaining for themselves some of these lower levels. Mm-hmm. Do we understand why that happened back then?
So at that time, it's a lot of times when we see that, it's related to coal. So and that's a severance, right? Where somebody's saying, I own the whole property and I'm going to sell you this portion, but I'm going to sever the coal rights. Or a lot of times it'll say all minerals. And so now we look at that and usually assess it related to oil and gas more often than coal. At that time, oil and gas production was like starting in Ohio. Mm-hmm. And I think Noble and Monroe counties have the oldest wells, I think, in the state. And I think the oldest one is still producing. So at that time, people were even then starting gas production, not knowing at all that it would look the way it looks 150 years later, right?
Right. And and you're going to get into more of this in another episode, more detail. The primary, if oil and gas figured into it in the late 19th, early 20th century, it was more so the homeowner could have free gas.
Right.
And so they weren't really concerned about royalties on selling gas because the market wasn't there. But by golly, if somebody's going to mine coal, you're going to want to retain that. And that's done through, and you'll get into the concept of a reservation or an exception in a deed.
Right.
Can you just give our listeners kind of an example of what we see when we see a reservation or an exception? I know the Supreme Court has said there are two very different definitions for those, but what are you looking at if somebody was looking at one of the deeds of a prior owner?
Sure. So a lot of times that deed would say, like, Tom White owns this property. Here's a section in the township and all the information, how many acres it is. Mm-hmm. And he's selling it to me. And that deed will say, sometimes it says reserving and accepting all rights to coal, oil, gas, all minerals. And it'll say something like that in there. So basically, the way I think about it is that you're handing over your entire bundle of sticks or spoons or whatever it is to me, except that part that you kept. So that's something that you hold on to from that deed. It's never being transferred.
And if I keep that, one of the sticks, one of the spoons that I keep is the right to develop that coal or oil or gas, which means I can invade your surface rights as the buyer
Right.
to drill, to mine, et cetera. And I think folks initially did that for coal. And then what happens though if, okay, I've sold you my farm, it goes on a couple decades, it hasn't been mined, so I kind of forget about it and I pass away. What's supposed to happen with my interest, my bundle of rights to those minerals?
So what is supposed to happen is that that's a real property interest, right? So it should pass and be transferred just like any other land or property you own would be. And ideally that's like through probate court, or it's recorded in the recorder, like you can find it and see that that transfer happened. Often we run into that not having happened, especially the farther ago it was. But ideally that transfer would happen just like any other property, like just like your house would transfer to whoever your heirs are at the time.
So, and you either do that through the probate court. The
Right.
Probate judge would give what's called a certificate of transfer of the interest in that property to your heirs, or as is more common now, there are transfers upon affidavit, transfer on death designation affidavits that you
Right.
can avoid probate. And if anybody owns real estate, please call us, because that's a simple way to avoid a lot of hassle, is just to
Right.
do an affidavit that says we're familiar with husband and wife upon the passing of the first spouse. The ownership interest passes to the surviving spouse, but the problem is when the property transfers between generations.
Right.
And if you can do an affidavit that says upon the death of the last spouse, it goes to the kids, and here's who they are, and you just file a death certificate, and it's very simple. You don't have to go to probate court. But what if you forgot about that interest? What if the family just forgot about it?
Sometimes that happens. I forgot, or maybe even didn't know at all, especially the more generations you get away. And so then we're ending up in situations where people are either opening a whole lot of estates to transfer interest, or filing quiet title actions to quiet title to inherited interest. And so we see a lot of that because people in Eastern Ohio kept these interests a lot, which I think we'll talk about more in the next episode too, is how often reservations would be made and what they would look like. And sometimes multiple people would make them on the same property. And how does that all get untangled? And so some of it goes into that too.
Right. But the general rule is, if I own an interest in real estate, upon my death, unless I have a will that's probated, or unless I've otherwise designated through a transfer affidavit, what happens to my interest upon my death in that real estate, be it surface rights or mineral rights, et cetera?
What transfers to your heirs?
Automatically.
Right.
And so what we often have to do is we have to catch up with what is going on in the family. Mm-hmm. Often, especially if like the reservation exception was made, we see a lot of it in the 1910 to 1925 era.
Yeah.
Okay. And families in southeastern Ohio fulfilled that biblical pronouncement to go forth and multiply. Okay.
Sure did.
I mean, lots of kids.
Right.
But upon the death of, if I were to give it to you, upon my death, it goes to my kids. Upon each of their deaths, it goes to their kids. Upon their death, it goes to their kids. What is the largest number of descendants that we've had to track in an oil and gas case? Do you have any idea?
I want to say like 60 or 70, but we've been involved in a case that the other side had to find like 300.
Right.
So, right. And I tell clients sometimes, like, I know more about your family tree, I think, than probably parts of my own, right? Because I have looked at it so often and know who's cousin and things like that. So it can be a lot of people.
It can be a lot of people, and you do get used to family names. You get used to places. Sometimes trying to figure that out is difficult. Genealogy searches, et cetera. It's a lot easier now with things like online services. But I remember early on that in Monroe County, especially because I think there was a couple of fires of public records down there,
Right.
that they assembled an index of graveyard headstones. And I think that's still available online. And upon the theory that if you're trying to trace heirs, people aren't probably going to lie about things and engrave it on a headstone. So that's
Sure.
viewed as a good source. But that's how detailed you have to get in order to figure out who has a potential claim on this reservation that might have been made 100 years ago. And that's
Right.
So it's not only we're trying to figure out who owns what. It's not only tracing what's in the county recorder's office with basically the deeds and certificates of transfer. It's also trying to figure out the genealogy.
Right.
And I think with that, we'll kind of segue into our next episode, where we'll talk in more detail about how we get into and kind of become forensic scientists and detectives about trying to figure out
Sure.
who owns what.
Yep.
Okay.
Sounds good.
Thank you, folks, for this episode.